So your failure to answer questions is confounding me. You've done it in instance after instance after instance after instance. What is the difference between giving your views here in this hearing room and what judges do every day, what professors do every day, what lawyers do every day? In each case, they have to state their opinion.
The only point I would like to make, because you raised the question, how is this different than justices who dissent and criticize, and how is this different than professors? And I think there are significant differences. The justice who files a dissent is issuing an opinion based upon his participation in the judicial process. He confronted the case with an open mind. He heard the arguments. He fully and fairly considered the briefs. He consulted with his colleagues. He went through the process of issuing an opinion. And in my experience, every one of those stages can cause you to change your view. The view you ask then of me, well, what do you think? Is it correct or not, or how would you come out? That's not a result of that process, and that's why I shouldn't respond to those types of questions. Now, the professor, how is that different?
Yep.
That professor is not sitting here as a nominee before the court. And the great danger, of course, that I believe every one of the justices has been vigilant to safeguard against is that turning this into a bargaining process. It is not a process under which senators get to say, I want you to rule this way, and this way. And if you tell me you'll rule this way, and this way, I'll vote for you. That's not a bargaining process. Judges are not politicians. They cannot promise to do certain things in exchange for votes. And if you go back and look at the transcripts, Senator, I would just respectfully disagree. I think I have been more forthcoming than any of the other nominees. Other nominees have not been willing to tell you whether they thought Marbury versus Madison was correctly decided. They took a very strict approach. I have taken what I think is a more pragmatic approach and said, if I don't think that's likely to come before the court, I will comment on it. And, again, perhaps that's subject to criticism because it is difficult to draw the line sometimes. But I wanted to be able to share as much as I can with the committee in response to the concerns you and others have expressed, and so I have adopted